Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me, as always, is Senior Associate from MBK Chapman, Sam Khil. Sam, good morning.
Good morning, Mike. How are you?
I'm fine, thank you.
Good to be with you.
So, Sam, yesterday we were talking, and we were going to do a different episode that we had discussed, but we got to talking about a news story that is kind of, it's a very local HOA, literally 3 miles from our office.
Yeah.
So we got to talking about it, and we decided off the cuff, let's do the episode on this. And the reason it's interesting is it ties into, it's a unique situation that in my 30 years I've never seen before. But it's a unique set of facts, but tied contextually to something that we see every day in our practice, which is the rulemaking authority of an HOA, the extent of that rulemaking authority, the reasonableness required under Civil Code 4350, and that sort of thing. And we've done multiple episodes on that. I've written multiple fact sheets and articles on rulemaking in HOAs and reasonableness and the standards. But this issue intersects beautifully and had us come to very opposite conclusions as to what would happen, we think, obviously it's a guess, we don't read the future, but what would happen in this case if it were to be litigated, what would happen? And we came to opposite conclusions, and that's what made me want to do this. And then we're going to close out with a different example, also addressing rulemaking authority on an issue that has become very popular in the last couple of years, especially, and that we've both podcasted about recently, and I've written a fact sheet on. And I'll put links in the description to all of that stuff. So I'll have a variety of links in there for you guys to choose from. But let's start with that first thing. Okay, let me paint this picture. And for those of you who, watch the news, especially if you live in Orange County or in Southern California even, you probably have heard of this story because it was all over the news recently, right? And that is, it takes place in an HOA very close to us called Nellie Gail. Now, Nellie Gail is a very large HOA in terms of the number of houses. These are all single-family homes, and most of them are very large, between starting at like 2 million and going up from there. And many of them have 1 or more acres of land. A lot of them are horse properties. And a lot of people have animals like horses and goats and chickens and stuff like that. Also, there are people that have lived there for a long time, even long enough, like the gentleman in the news story, you've lived there before it became an HOA.
Right. Yeah.
Okay. So what's happened factually is this, and the reason that's important is one of the rules that this Nellie Gail HOA has, and it's reasonable and it's enforceable and it's very common rule, is it controls the substance that fencing, the fencing that separates different properties can be made of and how high it can be. Now, let's assume for this discussion today that there is no city code on the height of fences, because often there is. Yep. And I didn't look to see whether or not Laguna Niguel has one, because I don't really care. It's not we haven't been retained in any case, so I wasn't going to go do that. But let's just pretend there's no city code relating to fencing height. So we're just looking at the HOA's rules. Sam and I both agree, HOAs in California are well within their rights to dictate what fences are made of and to dictate how high they can be in the community. To an extent, as long as it's reasonable. You couldn't say they can only be 3 feet high. That would be kind of stupid. But generally 6 feet is
pretty common standard. Yes.
Pretty common standard throughout the state. Okay. And in fact, that's what it was. That's what it is in Nellie Gail at 6 feet.
Correct.
Okay. But this person's fence is made of chain link and he's grandfathered in. Regardless of what the HOA's position might be, when they formed their HOA, they weren't going to be able to make him tear out an 1.5 acres worth of fencing is surrounding a perimeter. That's a lot of fencing, and that would be very expensive.
It's pre-existing fence, yes.
Pre-existing fence. Been there since before the HOA existed. Okay. Here's the scenario. This gentleman and his family owned 7 or 8 goats, something like that. They owned goats, okay? And coyotes were jumping that 6-foot fence. And for those of you who live in coyote country, which is pretty much any suburb in California, you know that coyotes can easily clear a 6-foot fence. It's not that hard for them. They're like little athletes, just jump right up.
Motivated ones, even 7 or 8 feet at times.
I've never heard of 8 feet.
Yeah.
6 I know of. My Malinois can get over a 6 foot. Never tested. A Malinois can climb over a 7 foot, but leap over, I don't know.
Yeah.
Okay. But the bottom line is coyotes can clear 6 foot fence, no problem. And they do it all the time. Well, these coyotes were doing it and they were killing his goats. And he tried all sorts of different things and nothing was working. Okay. Now, what's different about this case, and I don't remember how I came to learn this, but what's different about this case is these coyotes weren't just doing this at night.
Yeah.
Those of us who live in coyote country know, hey, take your dogs in at night, especially if you have little teeny dogs. But these coyotes were apparently killing goats in the middle of the day, the morning, at night. They were all times. It was a smorgasbord. Okay, this was a all-you-can-eat buffet. So what this gentleman did, his first thing he did was he added on a couple of feet to his fence to make it around 8 feet tall. Well, apparently I guess you're right. Apparently that didn't help because they got over that, right?
Right.
So it didn't help. Somehow the coyotes got over that and were still killing the goats. So then he added another foot of chain link to make it match. He had another foot, but that other foot angled out at a 45-degree angle facing away from the property and toward the exterior side of the fence. So you have like I guess 8 feet of vertical and then another foot or so of 45-degree angled outward.
Yeah.
And that stopped it cold. No more coyotes, no more dead goats. Now, I will say this. There are some statutes in California. Some of them were passed recently. Some of them have existed for a while that mandate that people take reasonable steps to protect their pets from grisly deaths, okay?
Yeah.
In whatever form that takes. And since we're not talking about those laws, I'm not even going to cite the statutes because I don't want to confuse everybody. Why should you even hear them? It's no big deal.
Sure.
But they exist. So that's the scenario. Now, this individual, from what the news stories say, this individual could have sought permission from his HOA, say, can I add on to my fence? Here's what's happening.
Right.
Apparently, he did not do that. He went and built it. Okay. I do know that the HOA and the homeowner spent a year or so going back and forth trying to resolve this dispute because they obviously cited him or noted that he was in violation. But I think the solutions they were offering were going to be monumentally expensive because just keep in mind, this person's property is bigger than an acre.
Yeah.
And when you're talking about perimeter fencing, now you're talking about a lot of square footage of fence. And chain link fences are banned currently. So if he were to replace it, he'd probably have to replace the whole thing. And that would have been 6 figures. That's my guess.
Yeah, if I recall correctly, 50 to 100K easily.
Yeah, I think it'd be more than 50.
Yeah.
Okay. So it was, to me, that's not reasonable. And I'm saying to me because this is the fundamental disagreement between Sam and I as to what would happen in this case or what's going to happen. Long story short, HOA has filed a lawsuit from what the news said. HOA has filed a lawsuit. And we have no idea what, I don't know. I haven't looked on the docket, so I don't know what process, how far into the lawsuit it is. I just know this was recently in, so I'm going to assume it's a recent filing, a brand new filing. Now, here's where our dispute was. I acknowledge, and Sam agrees, we both understand and agree that HOAs throughout California are well within their powers to set height limitations on fencing and materials limitations. No problem there. They're well within their rights to establish a requirement that before you make any changes or alterations to, let's say, the outside of your home, that you seek architectural approval first. Did this person do it? No, he did not. So no dispute there. The dispute comes, and correct me if I'm wrong, and I'm not because we did talk about this. The dispute between us was, this is a case I would want to take because I think I could win it. I think that is applied to this individual and people in his position all over the state, not just in Nellie Gail, pets, coyotes, fencing. I think because there are very few workable alternatives that wouldn't be extremely expensive, that the only reasonable solution was what this person did. And therefore, I think I could win it. Notwithstanding the fact that he violated an enforceable policy, and there's no dispute that he did that. You disagree. Talk to me.
Well, you really stacked the deck against me.
Yes, I did.
I mean, first of all,
I'm the host.
I have to say, we agree on the aspect of it being a well-settled law in terms of rules being promulgated to regulate height limits on fencing.
Yeah.
You even touched on the ordinance and city codes, which we're setting aside for purposes of this discussion. You also spoke in terms of the pre-existing nature of this, it being grandfathered. I think we would be remiss in not accounting for that.
Agreed.
And one quick thing, my sympathy for the homeowner under these circumstances aside, here's the argument to be made here. So a portion of this fence pre-existed the rules and the CCNRs.
6 feet.
Right. Now, the subsequent modifications that were made, to the homeowner's credit, he made a number of efforts. I believe he even attempted coyote repelling lighting at one point.
Oh,
yeah, so that was even part
that.
of it. So he went above and beyond in good faith, in his utmost good faith, to attempt to come up with reasonable means of
to protect his beloved animals.
100% understandable. That aside, on the well-established doctrine law aspect of it, I believe your reasoning is mainly on the reasonableness of it and based on equity. Right?
Mm-hmm.
The cost-prohibitive nature of some of these alternative solutions being offered by the board. And perhaps they meant well, and in their view, perhaps it was well-intentioned, and they attempted to work something out, except for because they were not personally vested, right? This was not their property, not their goats. Perhaps they did not quite, come up with the best tenable solutions here.
Mm-hmm.
And so, to expect the homeowner to incur 6 figures, give or take, right, to come up with a buffer zone or
well, let me interrupt you real
substitute
quick.
fencing.
You are forgetting one little thing, and that is in our experience, because we represent homeowners. We don't represent HOAs. We're a homeowner-side HOA law firm.
Right.
And Nellie Gail, as an HOA, is one of the more problematic local HOAs. There's lots of issues. There's lots of abuses. I've had dozens of consultations and been retained to go after HOA or the Nellie Gail HOA on other issues in the past. And so it's one of those ones where it comes up a lot because the board, it seems that the boards of directors at Nellie Gail, even though it's different people at different times, they are really, I would say, closer to the bad HOAs we talk about, just based on reputation.
And I would echo those, sentiments and those concerns. And it's, if I had to guess to some degree, what that's a function of is also probably because boards struggle with the somewhat unique nature of this community too, in terms of it being multi-million-dollar properties, acreage property, animal friendly, and so
not just animal friendly, designed for horses.
Right. So I think at times they also kind of try to test the boundaries of possibly skirting some of those components that this community was actually designed for. But just going back to my original point in terms of the pushback, let's say, on your position on that would be, okay, so once the modifications were made to the pre-existing fence, which was grandfathered.
And remember, he took a small step first. He just added a couple feet.
Yes.
Didn't work.
Right. So there were 2 or 3 stages of different efforts being undertaken to abate the issue and
first
mitigate
the
risk.
lights
Exactly. And so at that point, essentially what he did, and if he had come to us sooner, we probably would have advised him.
Well, he hasn't come to us. We haven't had anybody come to us. We're hoping he comes to us.
Well, my point is, if he had come to us prior to any of those self-help measures being adopted.
Had he been one of our PCs.
Correct. We probably would have told him that, look, once you start making changes to it, modifications to it, you're essentially potentially prejudicing your pre-existing fence, which was grandfathered. Right? Because now what you're doing essentially is...
I wouldn't have done that. See, I would have maintained the position I've taken here. If I was doing the consult, personally, Michael Kushner doing the consult, I'm going to tell him, let's fight this. Now, I'm going to tell him...
Fine.
Okay.
But what I'm saying, as far as the structural component of it...
I don't think you're risking the entire fence. The worst case scenario is you're risking what you added.
Okay. All right. But allow me to make my point on this. So what I would say is there's at least some risk of that argument being made. Okay? So an ounce of prevention or a stitch in time possibly would have been preferential here.
Okay.
In the sense that, what's the worst that could happen? You submit an application, right, as you're supposed to under the governing documents, and they say no. And now you push them on the basis for that to gauge their reasonableness.
And now weeks have passed and your goats keep getting killed.
Understood. And there's an urgency element here, and I totally sympathize with the homeowner. That said, I'm kind of going through the parameters of I guess, the reasonableness of the respective parties' actions, right, as pursuant to the governing documents, pursuant to relatively well-established HOA law, the equity part of it aside, because that also speaks to whether the board acted reasonably or whether they explored a resolution or solution to this in good faith, and that can be emphasized in subsequent.
But all we know is from what we've seen in the news stories.
I agree.
And from what we've seen in the various news stories, both print and on TV. It seems to me that the HOA's only solution was one that might have worked, but was extremely expensive. And there's something I didn't mention. I should mention it. The property has a tennis court. He has tennis courts on the property as well. The fencing on the tennis courts, which is not in dispute and there's no issue, are 10 feet high. And fencing in tennis is designed for one purpose only, and that is to make sure the balls don't go flying elsewhere down the hill, let's say. So the people playing tennis have to go and chase the tennis balls. That's why tennis courts have fencing. It's not to protect anybody. It's not like it's a hockey puck or a golf ball, which can kill you. It's a tennis ball. I've been hit at serving with somebody serving 60 miles an hour. I've been hit, and it leaves a red spot, and that's it. You can get hit in the head with a tennis ball going 60, and it's not gonna daze you. It's just gonna hurt. A golf ball coming that speed might kill you. Okay, a hockey puck will kill you. A baseball could kill you. That's why those arenas, in those sports, they have that netting up, okay, to protect people. You don't see that professional tennis. You see people sitting 10 feet from the court. The bottom line is that 10-foot fencing, apparently, according to this HOA, 10-foot fence on a tennis court is appropriate, and the goal there is to prevent tennis balls from going bye-bye. But a 9-foot fence is not appropriate to save the lives of animals, even though state law requires people to take reasonable steps to do that, and because nobody should have to face the constant death of their goats over and over again by these feasting coyotes. So why is a 10-foot chain link fence on his tennis court permissible, but 50 feet away, the now 9-foot or 8-foot, I guess 9, but really part of it's at an angle, is suddenly not okay, when the goal of one of them is far more important in my mind.
Listen, that's a fantastic point. And let's say if that tennis court, the same tennis court, had been, let's say, an amenity or part of the common areas and not really on his property, that may have possibly affected things a little differently.
I still wouldn't care.
Now,
it'd be the same argument to me.
Now, on the home issue, and you know this well, but for our audience, the argument obviously here is consistency, aesthetics, harmony of the community. So to the extent that there's consistency across those variables.
Let's talk about
that. Right? In terms of preserving a certain look, a nature, property values, that's an argument that's frequently and routinely espoused by the HOA side.
As situated, this person's property, it's a large, it's over an acre, is, as far as I remember, no neighbors have ever complained. There's no issue. It can't be seen from the street. So this is one of those more rurally looking properties, right? It's one of the ones that was designed for animals, whether it's horses or whatever, okay? The bottom line is no neighbors had a problem with it, and nobody from the street could see it. And the only way you could see it is if you worked really hard to go and see it. Now, I understand that harmony and aesthetics is not necessarily just solely based on whether or not it can be seen or not, and it's just the existence of it, right? But to me, harmony and aesthetics don't overrule a problem that's involving the death of your pets, right? That has to be solved. The status quo is not permissible. There has to be a solution. Now, as far as I recall from the news stories, one solution was offered by the HOA, and that solution, which may have worked, was extremely expensive. So balancing equities, which courts will often do, courts of law and courts of equity are the same courts.
Absolutely.
I think we've got a winning argument here. Here's the debate. Here's the issue. There are a lot of situations in California law, and the reason Sam and I decided this would be a fun episode is because this is really highlighting something that comes up more often than not, and that is very few of our cases that go beyond a mere consultation relate to bright line rules where there's a simple black and white yes or no answer. For example, is it legal? Somebody comes, is it legal for my HOA to limit the height of our fence? Yes, it is. That's where it dies. Okay, it's a bright line. Okay, the nuances and the gray lines and the blurring of lines occurs when you have a case that on the one hand violates what is otherwise a bright line rule, but there's such a good argument for the violation, and that's the debate. the reason we want to talk about this today is to let you, our audience, understand that a lot of the issues, most of the issues that actually end up in court don't involve necessarily, sometimes they do, but often don't involve obvious bright line rules.
Yeah.
They involve bright line rules underneath maybe, but how they interpret according to specific facts. And that's the debate here. My argument is this is a case I want to take, and I'd be willing to take it knowing and acknowledging what the law is on height limitations and materials limitations on fencing. And this, whatever the status of this case is, if it's, I'm going to go and take a look and monitor this case because I'm genuinely interested. My hope is at some point, the defendant, the homeowner, comes to us. That's my hope. And because I'd like to litigate this case. I really would. I hope that, well, part of me hopes that this case gets litigated because I think it's an important issue because so many people now have these. Coyotes are becoming more and more frequent because we're spreading further and further out into suburbs, into their encroaching on these animals' territories, and including bobcats, even mountain lions in certain parts, including around here, right?
Yeah.
Mountain lions, bobcats, coyotes. And so this is going to become more and more common, I think.
And we briefly spoke about, and just to briefly touch on this, and if you care to elaborate, please go for it. What if children, infants, toddlers are involved, right? I mean, you mentioned bobcats, right? You mentioned.
So let's say we're on. Let's say this situation didn't involve goats. It involved a couple of one or two toddlers that were grabbed during daycare. Then the question would become, well, where were the adults? Because coyotes don't typically go after anybody when there's adults present. Typically, right? Because remember, the whole reason why this has happened is because these goats are wandering around this. Because goats eat grass. You can't pen them up because the grass would be gone and you'd have to constantly rebuild your pen or move your pen somehow. They have to be able to eat. And so that's what they do. They migrate around this large property and they eat the grass and they don't necessarily hang out together. So it's a little different scenario. Plus, there is a difference, I think, between goats and 2-year-old children.
100%, yeah.
But it doesn't change the issue that these are still beloved pets. If it were children, I think it'd be even more on my side.
No, agreed. No.
Yeah,
I mean, that's what I'm alluding to.
I don't want to make it harder. I don't want to make your side harder. It's already hard enough. Even though part of me understands your side because you are reciting the law and you're doing it accurately. I get it. My argument is I don't care. In this case, the law doesn't apply. That's what my argument is.
Right.
I think I'd win it. Maybe I wouldn't. No guarantees. That's why I would kind of like to see what's going to happen here.
Yeah.
Now, let's parlay this into that next issue just in the last few minutes. We podcasted recently and I've written recently on the explosion in popularity of e-bikes.
Yeah.
E-bikes, e-scooters, e-motorcycles, but mostly e-bikes, okay? And in a tangential issue, we were talking about in those episodes and in the fact sheet, the fact that in response, one of the things HOAs are doing is they're actually starting to pass and enforce helmet rules for kids, right?
Yeah.
Which makes sense. So let's talk about the helmet rule in general, because applied to children, I think it's pretty non-confrontational and it hasn't engendered a lot of issues. Although I will mention one that I got as from a YouTube listener, from one of our podcast listeners who actually brought this up, and I responded to a question, and then I just did a fact sheet on it. And that is the surprise that we're going to get into in a minute, and its application to something else. Okay. But let's talk about children just for a second. Keep it to minors. Children being anyone under 18.
Sure. Yeah.
So Vehicle Code
21212.
Exactly.
Yeah.
Vehicle Code 21212 requires all minors, people under 18, to wear a helmet while riding bicycles, skateboards, non-motorized scooters, inline skates. And roller skates, to wear a helmet if they're riding on any public street or sidewalk or byway or pathway. Okay? So that's the law. It's called a helmet law. It's enforceable, and you could be cited for it. It's an infraction. Okay? So many HOAs have passed rules saying if you're going to ride a bike or scooter or skate or do any of those things on any of the common areas, you got to wear a helmet if you're a minor.
Right.
I will say right off the bat, it's enforceable and it's reasonable.
Yes.
And it's reasonable because it's just mirroring the law.
There's statutory basis for it. Yep.
Any HOA rule that mirrors a law in place, but ties it to the private property is going to be enforceable and reasonable on that basis alone. So no surprise there. And most parents that I know, I can't say most parents, but most parents that I know make their kids wear helmets anyway.
Yeah.
Okay. I certainly did. All right. And I don't recall whether I knew it was a law back then or not, but my kid wasn't getting on a skateboard without a helmet because I've seen the results of catastrophic head injury. When I was growing up, we had a neighbor across the street, college-age girl, had the whole life before her, wasn't wearing a seatbelt, got in a car accident where part of her body went through the windshield, including her head. And she ended up with the intellect and learning abilities of a 4-year-old. And as I grew up, this person I just saw always riding or riding. Her dad would ride around in this 4-wheel bike carriage thing around the neighborhood. She stagnated. I mean, she's going to need care the rest of her life.
It's heartbreaking, yeah.
It's heartbreaking. She had her whole life before. She even had a fiance. So this whole thing, I'll never forget that. But that's a head injury. Okay, I knew somebody that was riding a skateboard at a high speed in Kodo several years ago, fell, hit their head, and is still brain damaged to this day, and loss of a lot of function. Okay, those happen. Helmets save lives. Helmets prevent head injuries. There's dozens of studies on that are unequivocal. There's no debate. Reasonable.
Yeah.
Okay. Now, you have some HOAs, not a lot of them yet, but some that have said, okay, everybody riding a bike or skateboard or whatever in the common area has to wear a helmet.
Yeah.
Not just minors under 18, but adults too.
Adults too, yeah.
And that has caused a stir up among a lot of adults, and including questions to us by PCs. And those are enforceable too.
They are.
But obviously, when it comes to adults, it's not going to be because it tracks a statute, because there is no statute.
Correct.
So why would it be reasonable for adults?
You just said it. There's no statutory basis for it, as in the vehicle code for minors. But what you do have is premise liability and insurance-related reasons why an HOA can regulate on their common area property.
What does that mean? What are they worried about? What could happen?
Well, they're worried about risk of serious head injuries, for instance, in this case, because helmets are designed to protect or mitigate the risk of serious injuries.
Heads equals expensive.
Exactly. I mean, you could have, let's say, someone tripping over, pavement on HOA property, or let's say roots from trees, common area, trees. Sidewalks buckling. And while there may be simple mere negligence claims available to homeowners against that HOA, what they don't want to see happen from the HOA's vantage point is serious head injuries, possible, in some serious cases, wrongful death claims.
Right. It's a lot easier to deal with a broken arm than it is to deal with a broken brain and being crippled for the rest of your life.
100%, yeah.
And it could even affect insurance rates or cancellation. In fact, I could see an insurer saying you have to have a rule or we can't insure you for that.
Exactly.
I could see that.
Yeah.
So on that basis alone, on financial liability alone, an HOA is going to very easily be able to explain the logical nexus between the rule and a reasonable goal of an HOA, and that reasonable goal solves the problem that they're seeking to pass a rule on. Right. It's going to be deemed reasonable.
Reasonable standard is a pretty low threshold.
It's pretty easy.
Yeah.
Right. And I actually think it would be. Would it be annoying? Sure. As an adult, I bristle.
Yeah.
I bristle at it. But do I wear a helmet now? Yeah. I grew up in I was born in 1970. I grew up in the 80s. I skied my whole life. I never wore a helmet before. It just wasn't done.
Yeah.
In fact, people that wore helmets back in the 80s when I was a kid, a little bit making fun of them.
We're laughed at, yeah.
We're laughed at. I don't want to say like I was a bully, but we would be like, oh, what a dork. It's like, nobody wore a helmet except racers, right?
Major cultural change on that front. Absolutely, yeah.
I had a kid and introduced my son to skiing, and I have not worn a helmet since because everybody wears them now, and they really are important.
Yeah.
We just have much more knowledge and much more acceptance of that.
Yeah.
And it's a good idea. And I can't leave a kid. I couldn't risk having myself, debilitated because I didn't want to wear a helmet. I started wearing a helmet as soon as my son started skiing. And, it was just a sea change. But now everybody wears a helmet. You'd be hard pressed to find people on the mountain that don't.
Correct. Yeah.
And not that there aren't any, but most do.
Right.
And I think that's the case here. But there are still people that bristle. But I don't think they're going to win that.
And by the way, while there's been a social and cultural change on that front, and it's absolutely proven there have been some high-profile injuries as far as celebrities, et cetera, and even deaths.
Bono.
Unfortunately,
Not U2 guy, but Sonny Bono.
Yeah,
Cher guy. Yeah.
And so that has all, made a tectonic shift on that front. But one point worth emphasizing within the HOA dynamic is that this is in fact on HOA property common areas. So as soon as, with regard to adults, as soon as you exit, let's say you get out the gates or you're on public streets or public sidewalks.
Or you're on your 2-acre property riding a mountain bike.
Because the statutory basis does not exist for adults, right? Mm-hmm. Adults are no longer required to, yet you do see people still wearing helmets, but that's optional.
Yeah, I don't think an HOA rule that tried to control you wearing a helmet on your own property would pass muster.
No, it wouldn't.
But I also don't know if a rule regarding a child on private property would pass muster because the statute doesn't apply to that either. I'm not sure an HOA can mandate at all what you do on your own property when it comes to that safety standard issue. Mm-hmm. There's no liability issue there because any root or issue that comes up that causes you to fall on your property is your problem.
That's a good point.
HOA would have there's no nexus there.
Correct.
Between a legitimate interest of the HOA and the solution they're proposing based on that rule.
Well, imagine that, a kid riding a scooter in their own backyard on a single-family residence detached, right?
Yeah.
No HOA purview over there. Them trying to regulate them, citing them, or calling them to hearing.
It's almost laughable.
It's laughable,
and that to me is the hint. It's not going to be reasonable.
Right.
The reason we thought this was a fun issue is it kind of shows the thinking that us as attorneys, that we as attorneys have to engage when we come up with a problem. We start with the statute or case law. We start with bright lines, and then we work backwards from there. At least my technique is that I start with what I call the easy case. Mm-hmm. Let's make this as easy as possible. Let's make all the facts go a certain way so the answer is easy. And then I start adding wrinkles. Mm-hmm. And then eventually we get to the situation before us. Yep. Now, what are our options? That's kind of how we analyze things. I thought it'd be a fun look for our audience to see that. Yep. And in the context of these two issues, this Coyote thing and Nellie Gail and this helmet issue, they kind of can see how we do that. If you like this episode, please hit the like button. If you haven't already done so, please subscribe to the channel HOA Hell. If you want to leave a comment, please do so. Until next time, have a wonderful day.